Welcome to the Voice of EB-5. We're excited to have you here today. I know you're calling in from Philly. So Dan Lundy is an immigration lawyer. He started in 2006 at a New York law firm. And in 2011, he went to Klasko Partners. He is a partner there. Typically, Dan works on I would say more on the developer side, putting the deals together, strategy, a lot of the forums. Dan, welcome to the Voice of EB-5.
Thanks. Nice to be here.
Well, before we get started, Dan, did I leave anything out of your background and your history in immigration?
Well, a little bit. I manage our EB-5 developer and regional center practice along with Ron. Also manage the litigation practice group. We do a lot of suing USCIS for either not making decisions or making stupid decisions. I've been practicing mostly EB-5s now since the beginning of 2012.
Is that called a mandamus, by the way, when you sue the government?
Mandamus is a delay action. When you sue for the government hasn't adjudicated your case and it's been a while, we file what's called a mandamus to force them to speed up.
So Dan, a lot of back in the day when we started a long time ago, I know you've been in the space. I don't know when we met, years back. They said Dan's the lawyer's lawyer.
Thank you.
And so you're known as a lawyer's lawyer. So tell me, how did that reputation come about? I know it wasn't someone from your firm who said this, but did you solve some problems for lawyers, or how did that happen?
Yeah, I have always handled the more esoteric, complicated pieces of immigration. So, it's not uncommon for other attorneys to come to me for solutions to novel problems or difficult problems.
Let's hear a novel problem. Without talking about names, let's hear a novel problem. I want to hear this.
Well, some people will tell you that there's a project out there that's quite controversial right now for, it had an expedite for a long time where everybody, all the investors in the project were granted an expedite. Well, I helped get that expedite. I've helped to restructure deals where they've gone sideways, with some success. We've changed deals from doing mostly one thing to just partially something and a little bit of something else to salvage the deal and get people approved. A lot of appeals I've been dealing lately with issues about money, about the way the loans are structured. We had one case where originally the EB-5 investors were going to put their money in and there was going to be a senior loan, but it ended up being changed so that the EB-5 investors' money was being used to secure a line of credit, which was used to secure the senior loan and then would be deployed into the senior loan. And USCIS objected to that, but then they switched back to a normal senior loan. And I was able to argue that the money doesn't have to be invested and at risk until they get their conditional green cards. So whatever happened between the time the 526 was filed and the 526 was approved didn't really matter. I mean, I made a good argument that it qualified anyway, but if you don't like it, you don't think it qualifies, well, it doesn't matter. And they actually bought that argument for a change. Go ahead.
I actually have a question for you then. I have a more of a technical question for you that I've heard of. I want to throw that out to you. Projects come to you, a project comes to you and they're 6 months in construction or month 10 in construction or month 15 in construction. And let's just say they have 3 months to 6 months left of fulfilling all their construction before they get a certificate of occupancy. Say, call it 6 months. What's the determining factor? I mean, what do you say to them if they want to do EB-5 and they're 6 months out from being done, or 3 months out from being done, or maybe a year out from being done? What's the rule there?
If they can still use the money directly and they can raise it in time, great, no problem. As long as it goes in during the project and creates jobs, or if it's, let's say it's a hotel which has an operating component. So, not only can the money go to construction, but it could go to operating, go to hiring people. The other thing is, even once you get a CO, there's still, 6 months or more punchless items, and you don't pay the last invoice for quite a while. So realistically, there's still some more time there.
Does the money has to directly go to pay the EB-5 construction, or can it go to pay down the construction loan, which has been funding the construction?
Well, you can get bridge financing, which is short-term, temporary, and contemplated to be replaced by something else. And if the bridge financing is spent on job-creating activity before you've raised the EB-5 money, you can replace the bridge financing. But it's tricky because it has to be short-term and temporary, and USCIS has never quite defined this. And USCIS actually Monday is supposed to tell us what they think the sustainment period is, what they think the period that you need to invest and keep your money invested and at risk is. Apparently, they view it differently for people who invest now than people who invested before the change of the law. We don't know how long short term is going to be. If they come out with a policy that says you only have to invest for 2 years, 2 years isn't going to be short term, right? If you have a bridge for 2 years and you're only supposed to invest for 2 years, they might not take the position that that's short term. It's a little bit flexible and it's a little bit uncertain right now.
I don't understand how that's related, because even if you do replace a construction loan or a bridge loan, call it a bridge, you can still keep the money employed or deployed for a period of 2 years later. So the sustainability portion that you're talking about can come after the payback of the construction loan. Is that not right?
Yes, that's true. But it's supposed to be replaced with more permanent financing. But if your more permanent financing is the same length as your bridge financing, then it doesn't seem more permanent, right?
Yeah. No, let's say your bridge financing, your construction loans are generally 2 to 3 years, right? 1 to 3 years. Okay. So let's say your construction loans 1 to 3 years. Let's say your EB-5 loans 4 years. In your situation, I think what you're referring to is when your construction loan is longer than your EB-5 loan.
Correct, because then it's not really permanent financing, right?
How does that even happen, though? If you're how can your EB-5 loan only be for 2 years?
Well, at the moment it can't, because look, even if USCIS comes out and says that you only have to invest for 2 years, that's never going to happen because it's not commercially reasonable. The deal cycle is longer than 2 years. And so no quality, decent project is going to take your money for 2 years and give it back. It's going to be a 3-year, 5-year, 4-year. There's going to be some loan term that gives the project the ability to build the project, stabilize the project, and refinance or sell the project. And that doesn't happen in 2 years on a decent sized project.
Yeah.
Regardless of, even if it is only 2 years, I think commercially it's not going to happen, and the loan is going to be longer than 2 years. USCIS originally came out and said a bridge financing is 1 year or less. We fought that. They backed off. They haven't given upper limit on what the bridge is at this point. But if it's 2 years or more, I'd be a little hesitant going forward. Now, there are ways to structure
2 years or more.
Yeah. For instance, we tend to make a bridge loan a year with eligible for 6-month extensions.
Right. But there's projects on the market right now that have had longer construction loans than 1 year and even 2 years getting refinanced by EB-5.
Well, everything is about risk, right? And how much risk you're willing to take. But so we've had to argue that a construction loan inherently is a temporary loan. When I advise my clients, I say, look, we want to bridge this. I say, okay, get a bridge loan that is separate from the construction loan. Structure it as a shorter term loan. Yes, I know in the commercial world, a construction loan is inherently a short term loan because you're going to refinance out of that at a lower interest rate at some time in the future. That's reality. Reality and USCIS don't always mix well.
But a bridge loan and a construction loan, I think, are the same thing. Construction loan is temporary.
Actually. In the normal world, in the commercial world, yeah. Well, a construction loan is a construction loan. A bridge loan isn't necessarily a construction loan because a bridge implies that you need money in the short term, whereas opposed to construction is going to take me from start to finish. And I'm going to build my building. I'm going to refinance it.
So maybe we should argue to the USCIS that all construction loans should be counted as bridge loans.
Yes, that would be great and logical if they took that view.
Are we currently arguing that? Is someone arguing that to them right now?
Yeah, we've argued that.
Yep. Did you win the argument or did you lose the argument?
I've never lost the argument. Let's put it that way. Part of my job is to make things easy. I don't want to have a developer do something that's going to result in a long, drawn-out fight with USCIS. Even if we ultimately win, it's better if we can simplify and avoid the headache. A lot of what I do is actually exactly that, is structuring around the optics and trying to reduce the potential headaches. Like, yeah, that'll probably be approved, but if we can do something easier, why not?
Okay. Well, I actually like this topic because this is really relevant to developers listening to the podcast. I think Some of our podcasts are towards the investment side of the investors. I think this is really good for the developers to know this. Let's dig into this a little deeper now that we found a really interesting topic. With the construction loan and with your bridge loan, let's just hypothetically say that you could pay back your construction loan. How about the interest reserve? Can that be paid by EB-5 funds or no?
So an interest reserve to pay back the EB-5 loan is absolutely prohibited. No good.
Prohibited. Okay.
Yeah. An interest reserve to pay the senior or to pay the construction loan arguably is an allowable use, right? It's going to be used eventually. I would want to see that it's going to be used within 2 years. And honestly, if there's a way to not use the EB-5 money for that, I'd prefer not to, because I've seen USCIS question it. You have to understand that they typically don't have business backgrounds, right? Like there is nobody in leadership of US IPO that has anything but a government background. There's nobody there that has a business background.
We're going to have to take that out of the video. They're going to see this.
Okay.
They're going to see this. You don't want a bad name. We're not going to go there. So let me ask you another question. Just assume that the USCIS does see this. So we'll assume that.
Yeah.
Can you use EB-5 funds to pay 1 point on a loan? Let's say the developer owes the regional center or the NCE 1 point acquisition fee or 2 points origination fee. Call it origination fee.
The developer owes the regional center.
The NCE, the developer,
No.
the borrower, the JCE owes the NCE. No. Oh, they can't use it.
You could use the EB-5 money if you owed a point on the senior loan. You can't have a guaranteed return on or of capital. If you have an interest reserve on the EB-5 or you pay yourself a point, it's kind of a guaranteed return. It's a legitimate cost. It's a legitimate project cost if it's a point due on the senior, right, to the bank. But you can't use EB-5 money to pay interest on the EB-5 loan.
How about costs associated with the legal documents, the upfront legal documents for EB-5?
Nope.
Can that be used?
They can come out of the administrative fee, but they can't come out of the principal investment of the EB-5 investor. At this point, the 800,000, $1,050,000. And by the way, we run into this sometimes where there's like a $25 wire fee. No good. You've got to.
The wire fee.
Yeah. Transfer another $25 and pay another $25 wire fee.
So the wire fee has to be over the 800,000. It has to be 800,000 and $25.
Yeah.
Because we're kind of in a hot place and a hot topic, I think we're going to probably end up publishing this sooner than later. I'm going to ask our team to publish this really quick online. One of the things I wanted to ask you about, I actually talked to Bob Schleposky today, and we were talking to him. We have a press release coming out in a few minutes that's hitting, and today is obviously Monday, the day after everything went down, or considering today is the day that things happened at Signature Bank. What do you think happened? What's going on with the EB-5 funds? What do you think, Dan?
I think the EB-5 funds are perfectly safe. I mean, I think the Fed has backed up all the depositors. I don't think there's any risk of deposits disappearing. I don't know what's going to happen. I don't know if they're big in lending. I don't know what's going to happen to loans that they were going to fund, but the deposits, as far as I know, the deposits will be safe. I think they've created something called like Signature Bridge Bank or something. I don't know how it's going to work, but I suspect that there'll be a reorganization, a restructuring, and somehow they'll get back to business.
Yeah, if I'll repeat the exact the name of this here for you guys. The name of it is, I wrote it down when I talked to Bob today. The new company is called Signature Bridge Bank, and the FDIC is running it, having oversight over it with a guy named Greg Carmichael. Did you hear about that too, Dan? A guy named Greg Carmichael. He's a CEO coming from the FDIC side, and then they still have their CEO that's currently there, and that CEO stays there during this whole period while this is happening. But what would you advise your clients to do at this point? Are you advising them and saying, hey, switch banks? Are you saying, hey, stay with Signature? What's your advice?
I don't know enough to give that advice yet. So I don't know exactly what's going to happen, but I do know the money is going to be safe, so nobody should panic. That's the
same thing Bob told me, not to panic. And the government's backstopping it. If the government's backstopping it and Signature changes ownership, does that even matter?
Shouldn't. as long as they
Yeah.
honor all their commitments. I have to say, because I find the irony here amazing. I'm glad that signatures in EB-5, because we hear all the time from banks, oh my God, EB-5 is too risky. We can't be involved in EB-5. Well, they're involved in crypto. Crypto is inherently speculative, has no intrinsic value. It's not based on anything, and it's highly unregulated. But EB-5 is too risky. Go figure.
That's crazy, huh? We get a bad rap, but crypto is the one that's causing all the problems.
Yeah, like, our money, we put it in escrow. Like, there's nothing terribly controversial about it, but for some reason it's deemed risky. The rest of the banks out there, wake up and start dealing with EB-5.
We're creating jobs. What's crypto doing?
I really do hope Bob and everybody else lands on their feet, and this just turns out to be, well, I don't want to call it a simple restructuring, but
I hope so too. And
as it can be.
Bob is very confident, and rest assured, the EB-5 investors are going to have their deposit accounts insured by the government, unlimited. It's an unlimited insurance right now, so that's a great thing. Was your phone just going off the hook or what when you heard this news?
Things have been popping a little bit, but
the weekend?
No, well, today, a little bit.
Is there options, Dan, out there for other banks? What's going to happen, you think, in this whole banking regime for EB-5?
EB-5 will find a way. There aren't a whole lot of banks doing EB-5 right now, but there are some. A lot of it depends on developer relationships. And if I'm doing all my banking with you and borrowing money from you, you'll take my escrow.
Dan, does there have to be an escrow, or can it just be put in?
As a matter of fact, there doesn't have to be an escrow. And this is a function of processing times. Like back in the day when EB-5, when it took 6 months to process a 526, everybody escrowed until approval of the 526. It was good for business. It was good for the investors. It gave USCIS a chance to look at a project before all the money went away. But with processing times in the years now, that's just not commercially feasible. So unfortunately, escrow is usually just until you file the petition, which isn't all that much different than if you put the money directly into a segregated account with an agreement to get it back.
So, Dan, are you saying the escrow is being released before the 526 is approved, correct?
Oh, 100%. At first, it was escrow till approval because processing time was 6 months, and that was reasonable. It started getting longer than that. We started doing a holdback where we'd hold back. The historical denial rate was 10 or 20%, so we hold back 10 or 20% of the money. And we started running into problems where the project would be finished before the money would come out of escrow because USCIS takes too long. We couldn't wait till everyone gets a petition approved, even for the last 10%, because it might not go into the project. So now, thanks entirely to USCIS processing time, we only escrow until file.
Let's bring this up here, Dan, because I think this is a pretty good hot topic. Why even use an escrow? I mean, now the signature potentially may be acquired by a new company, and I don't know if they're going to end up doing EB-5. Who knows? They're going to eventually get acquired, right? Why even use an escrow bank? Why not just send the money to Wells Fargo or City National or whatever bank you use and have escrow instructions to the investors on the release between you and the investor, perhaps using an escrow agent or maybe using a separate escrow company? But why not accept the money into the bank and then upon release have some kind of functionality there? Is there a way around this? Or
I mean, if there's a third party, there's the escrow bank. So the bank account itself doesn't matter. It's the escrow agent. Like somebody takes the money, and then when you give them proof that the release conditions are met, they release it, whether it's into your bank account or into a third party. There's maybe a little difference. I mean, I guess it's harder to manipulate if it's at a third party, but it's not a huge difference, right? If somebody else is back checking you to make sure, yes, the release conditions were met before that money gets used, that's
what are the
function.
release conditions? Dan, what are the release conditions?
Typically, you filed the 526. Sometimes we raised at least one investor and the project is going forward. I mean, the problem is you can't, again, this is a USCIS problem. The USCIS won't let you include other conditions in that escrow where you get your money back if certain things don't happen. Like you can't put your money in escrow pending the senior loan close. If the senior loan doesn't close, you get your money back. Well, that's not at risk.
Does the RAA or the original EB-5 Act, does that mandate an escrow? Do you have to have one?
No. Nope.
Do you have to have a condition where you file the 526 at the same time you release the escrow?
Nope.
So why do we create this regulation for ourselves for this industry?
Well, originally it provided a good amount of safety to the investor, right? The investor, if your money is in escrow till approval, the investor gets to see that the project is approvable before they release their money. Unfortunately, we can't do that anymore, but it gives a modicum of protection in case, like, let's say they decide they're going to invest and then their attorney tells them, look, your source of funds isn't approvable, take it back and we'll do something else. There's somebody there to give it back. From the developer standpoint, the regional center NCE standpoint, it does provide an extra layer between the NCE account and the money. The escrow agent's going to do OFAC and going to do your politically exposed persons and KYC AML on the money before the money comes in.
Oh, they do that? So Signature does that right now?
Absolutely. If they don't pass those checks, the money gets bounced back. It never gets to the NCE.
Oh, wow. So KYC, anti-money laundering, and all that is done at the escrow level.
It's done every time you move money from bank to bank. Escrow, it's done when the money comes out of escrow into the NCE account. The NCE bank is going to do it. Every bank has to do it every time you move money.
Does it have to do with an escrow? Or does it have to do with just the bank's requirements?
No, well, treasury requirements.
Treasury requirements. So not necessarily do you need an escrow because the bank's going to do that anyway.
Right. But it's not the NCE account. So there's never any tainted money. You have an extra layer of protection on the NCE account because once you put the money into the account, technically money's fungible. I mean, USCIS thankfully hasn't gone that far. It's just one more layer of insulation to make sure that's clean money.
I've heard of other companies not using escrow. I've heard of regional centers not using escrow many times. Do you see that regularly or do you see that very infrequently?
I think we're going to see it more because, as you said, escrow used to serve a pretty good function and now it's really just a tiny bit of protection.
And I don't know if you've heard, I've heard there's a trust company that is used to hold EB-5 funds. I've heard of an escrow company that used to hold EB-5 funds.
Yeah,
They're
title
no longer
company. I mean, I've even heard of attorneys using their IOLTA account. I wouldn't get into that business myself, but yeah, any escrow will do.
Well, if you think about it right now, though, Dan, I mean, they're making on a regular money market account, you're making a lot of money. So whoever does hold the money does potentially have a benefit for if it's a duration of 6 months or a year. Right?
I'm getting 3.5% of my savings. I mean, yeah, right now is a good time to have money in an account.
Technically, if an EB-5 investor has their 800 grand locked up for a year and you're making 3%, that's 24 grand in a year, right?
Yeah. It's nothing to sneeze at. Imagine now it's 10 investors or 100 investors. Yeah.
Well, it may make sense for businesses to pop up. I know there's a couple folks that came to our events and a couple of new banks jumping in. But have you heard of any particular names or anything of banks in case developers are looking for banks to use?
I don't want to give out names because I might make people angry. Like, hey, that's my bank. Why do you share my bank?
Dan, maybe that's another reason to use your services.
Yeah, I can't broadcast them on YouTube.
Hire Mr. Lundy here and you get the banks. Let's talk about some of the problems you solve. I kind of like this aspect of arguing to the USCIS and you being one of the guys that explains things in layman terms. I know this construction thing is a big issue. We talked about it, the bridge that hopefully will get resolved and hopefully USCIS will understand a construction loan is a bridge loan. It's our goal. Yep. But what is another hot issue that you see for projects trying to get started up and they come to you and say, Dan, can you help us? What's another one like that?
We've resolved most of the structural issues at this point. Like back in the beginning, we had to come up with structures that they would approve. Like USCIS didn't know what a mezzanine loan was. They didn't understand preferred equity and how preferred equity is not a guaranteed return. But we've managed to get rid of most of those issues and most of the issues now.
Okay, so let's hypothetically talk about tenant occupancy. And I know that's an old issue. Is that resolved if you own a
new issue too now? It is an old issue and it was USCIS did away with it, but Congress brought it back.
So let's say if you own a percent, if you build a building and you rent it out to a hotel. Let's say you rent it out to a hotel chain, you build the hotel, they rent it out, but let's say you take a percent of ownership in that hotel. Does that satisfy the requirement that you're part of the operating jobs?
Okay, we're talking about regional centers, I assume.
I'm talking about the JCE getting credit for the jobs, not only for the construction, but on the operational side.
Yeah, so if the
So
JCE owns a piece of the operating company, then you have no problem.
as a percent fine?
There is no particular rule on that, but but for the EB-5 money, the jobs wouldn't be created. And if they own some of it, if they own a piece of it, it's not tenant occupancy. If they own a piece of it, it's not a tenant business, it's your business, at least indirectly your business.
As
Now,
an LP?
1%, USCIS might complain about 1%, but I can argue that 1% is allowable. Again, here's something where I would say to the developer, well, why don't you buy 5% or 10%, not 1%?
I got another question for you, Dan. I like to fire these technical ones off. I'm thinking they're technical. Maybe for you, they're easy. Let's say you buy a project that has done all the horizontal work, and you buy it and you're trying to get credit for the horizontal work done, which is, the infrastructure, the roads, all the stuff that comes before you start building vertical, and you buy it. How do you structure it to get that credit for the horizontal jobs that you just bought from the developer?
I would tell you that you should probably see if you can do it without those jobs, because
Okay.
it's going to be different. If you didn't put any, you, the developer, didn't put any money toward that infrastructure or whatever, it's going to be hard to claim that as a project cost. Although, it's a land cost, right? You're buying the land and it has improvements. I could come up with an argument, but I'd prefer
Isn't
not
there
to.
a but-for test? Isn't there a but-for test?
Yeah, but that might be stretching it a little bit.
So you can't use the but-for test there. Okay.
I mean, if I had to come up with an argument, I could come up with an argument, but I would try to advise somebody take a few less investors or figure out another source for the job creation.
That's another question that we get to, is taking less investors. I talk to a lot of economists, and you seem to be the right guy to ask about this stuff. What's a normal buffer? And why not, if you're doing construction only, why even have a buffer if you know you're going to use your construction budget? Why is that concept even out there? I've heard economists say use 40% buffer, use 35. Why use a buffer if you're going to spend $100 million on construction and you're going to make $100 million worth of jobs? Why even have a buffer if there's no operating indirect jobs? I mean, I'm sorry, there's no operating jobs in my question. There's just construction jobs.
What happens if you get halfway through construction and run out of money? Right.
Question.
If I have a 30% buffer and I get 70% through construction, I might just have enough jobs for everybody, even if I never finish.
What if you have bridge financing and you're 3 months away from finishing the job? You've had temporary loan. You've contemplated EB-5 because you have bridge financing, and you're now raised EB-5 to pay your bridge financing, and you've already spent $50 million. Do you need a buffer?
Well, no, at that point, you're good, right? You should be okay on the job creation.
Yeah. So if you've deployed 40, let's say the construction budget is 50 million and you've deployed 47 million. You technically have done 47. You probably don't need a buffer for the 47, do you?
Right. No, you don't.
So why is it that
I know they allow bridge financing. Bridge financing is, we've argued, we've won. They have this policy that allows us to use bridge financing and get credit for the jobs. I always advise people that, hey, yeah, I know we can use 100% of the money to repay the bridge, but I'd prefer not to, because the optics of it, if at least some of the EB-5 money is going directly to job creating cause, it just looks better.
Can you use it for operating costs?
Yeah, no, or you can use it for construction costs. But some of that money is tied directly to the job creation. It's just more palatable for USCIS. It's an easier pill to swallow. So, yes, you don't have to. The policy 100% allows you to replace the bridge and nothing else. But I'd prefer if you did.
So let's just say 75%. How's that? 85% to pay back the bridge, 15% to pay direct construction.
Yep. Yeah, I think that's great. It just gives you a bigger hook to the job creation.
Dan, remind me to send me a text so I can send you a client. I got these are good answers. I like your answers. Okay. Let's just hypothetically say you're using a buffer of, I don't know, 10%. 15%. Would you feel comfortable filing that case if it's call it $47 million spent and you maybe have a 10%, 15% buffer? Or would you tell the client, no, let's go 35%, let's go 40% buffer? And you're actually just doing the 47 million that's been deployed. How would you take that? I know the economist is going to come back and say, take your buffer of 30 or 40%, but what would Dan say?
It's a marketing issue, right? The other reason you have a buffer is so you can go to the market and say, look, we've got 3 times the jobs we need. Our project is safe. You're going to get your green card. For USCIS, you technically need 0 buffer as long as everything goes right. It's mostly a marketing issue. And it's, for us lawyers who have seen things go sideways, I'd rather see you have a buffer, because if you don't, I had one client once actually came in under budget.
Oh, wow.
On schedule and a little bit under budget once in a lot of deals. It doesn't happen that often, but what if you get a pleasant surprise?
Yeah. The other thing is like this 2-year rule. Is that still a rule? Like you need to do construction for 2 years for it to count as jobs?
If it's less than 2, so if it's 2 years or more, you can count 90% of indirect jobs. The direct jobs are model jobs, so it's not really an issue. It starts to get more complicated when it's less than 2 years, because then I think you can only, honestly, I have to check, I forget. I think it's 75% direct jobs, but then you can only use the percentage of jobs that matches the percent of 2 years. So if it's a 1-year project, you can only use 50% of 75% direct jobs.
Oh, interesting. So 2 years is for the construction jobs that are direct. You get 90% credit for the direct?
For indirect.
For indirect.
You can go up to 90% indirect.
What does 2 years mean? Does it mean the moment that I purchased the land and I hired the lawyer?
Boots on the ground.
What is a boot? Is that a boot doing
Site
the
work.
horizontal?
Yeah, demolition, site work, excavation.
Okay, so let's just say the demo is the boot.
Probably not your surveyor going there months before the project or your architect going to take a look. It's the first guy swinging a hammer or a shovel.
Okay. And when is the project done? Is it when you do FF&E? Because sometimes there's tenant improvements.
When the last invoice is paid. It's kind of,
After the tenants moved in, they still have to do tenant improvements, right?
if you're building an empty shell, delivering a core and shell or whatever, yeah, your tenant improvements could be really significant. I mean, they could be a big part of the budget. So yeah, but that's construction. The problem you run into sometimes is like you'll finish, you'll get your CO, everything, do your punch list, everything will be done, and then it'll be a year before you get your tenant. We start running into interesting questions there.
But what if you get your tenant right away and the tenant pays for the TIs? Well, what if the tenant pays for the TIs?
So you have the tenant pay you and you do the TI. There are ways to deal with this.
Right. So the tenant pays you, you do the TIs, the construction can go on for a longer
period.
Right,
because most of the time there's a TI allowance. In that case, the developer is actually paying for some of the tenant improvement. There are ways to structure this. Let's just...
sorry to nerd out on this kind of stuff, but I find it kind of interesting to expand the 2 years. People always ask about that. They're always the developers that call us. We have a call center and they call us and they ask us, we send them to different clients. They're like, what do we do about the jobs? And how do you make sure you're getting jobs for this? So I think it's a pretty relevant question. A lot of people ask that, actually. How do you get the full credit for the jobs?
If it's a big enough project, it's going to be 2 years.
Right.
Right. Unless you're looking for a handful of investors, it's going to be 2 years.
Right. So when people come to you and say, hey, how much can I raise? And they only have construction jobs to work with, do you have like a certain LTC percentage in your head where you're like, for every $100 spent, you can get $50 EB-5? Is there a certain number you instead of calling?
Yeah, ballpark, if your construction is over 2 years, you get somewhere between 12 and 15 jobs per $1 million spent in construction.
So we talking like more layman terms for the people, like every $100 you spend in construction, how much EB-5 loan can you get?
This is more a marketing question than anything else.
Assume the buffer.
You can structure whenever you want, but if you can't sell it to investors at $1,050,000, I mean, you could do close to 100%. Because for $1 million, you're getting more than 10 jobs if it's over 2 years. You're only getting about 6 jobs if it's not.
Well, let's say you deploy $100 million in construction. How much EB-5, without looking at the operating jobs, how much EB-5 would you say you can raise for deploying $100 million of construction, soft and hard?
I assume it's over 2 years at $100 million.
Yeah, over 2 years. Yep.
Close to 100%, 90%.
Without operating jobs?
Oh, yeah. The multiplier depends on what region you're in. Most of the multipliers are for $1 million of construction expenditures are somewhere between 12 and 15 jobs. Wow. So if you have 100 million, you have 1,200 jobs or whatever.
Right. Do you use an economist to come up with this for yourself, or do you end up doing it yourself with the job?
No,
count?
100%. I mean, I know from doing so many of these that's the ballpark, right? It's not a hard and fast rule. It's a ballpark. The economist is going to be the one to actually give me the real numbers.
So do you have a choice? Do you use one of 3 economists? Do you use all of them? What do you do with economists? I'm guessing you're the one that reaches out to them.
Well, sometimes people already come with them. Yeah, we have a handful of them.
Okay. I've heard very varying responses as to buffers and all this stuff. Do you get that too? Do you get it all over the spectrum?
It's not actually the economist's job to, no offense, guys. Don't yell at me. Don't send me hate mail. I have this conversation with one or more of the economists frequently. Like, leave the arguments up to me. You do the economic work. You do the modeling. Let me decide, make the legal arguments and how it fits. Like, I just need you to tell me how many jobs there are. They're being good professionals and telling you and giving you good advice when they say you need a job buffer. But it's up to them to crunch the numbers, not necessarily give you legal or marketing advice. But it's good advice. It could be a buffer. But I also have had conversations with people in the past. I know economics is an economic field and it's a science and an art, and I have certain standards. We know what's been approved by USCIS. We're not looking for a Nobel Prize. We're looking for an economic study that works for USCIS, right? That it's going to get approved based on methodologies we've used before. And in that framework, we can be selective, and we're not making anything up. We're not fabricating anything. We're not gaming the system, but we're going to pick favorable numbers. We're going to use the model that's going to work for us. Some people push back on that. Listen, our standard here is what is approvable, not what is Nobel Prize material.
That's good. So it's been a pleasure talking to you, Dan. I've learned a lot on this conversation. I want to ask you a bigger picture question, though. What drives you in the morning in this space? And it's not really immigration, I guess. It's more development. And what's the driving force here for you in this space? Is there a certain thing that pushes you to help your clients or the developers on this?
It's a lot more fun and interesting than a lot of other immigration stuff. I've been in several billion-dollar deals at this point. And I can now talk credibly amongst the, $1,500 an hour real estate attorneys and contract attorneys. It's certainly more interesting and more challenging, and there are always new wrinkles. There are always new problems to solve. I have to admit, I sue the government a lot. Sticking it to the man once in a while is fun. And we win, not always, but we have a pretty good track record of winning. I like making good arguments. I like solving complex problems.
Are you a litigator, Dan? I thought you were doing the corporate stuff. Do you actually go to court?
Well, most of it is on paper, but yeah, occasionally.
Oh, wow.
It's when you're challenging an immigration decision, there's not really a trial. There's, it's usually just on the record, on the existing record. It's mostly done on paper, but every once in a while we get to argue something.
Thanks for being on this call. You're actually our first live podcast. So I'm excited to publish this very soon.
Thank you.